Good morning, Your Honors. May it please the Court, Ivy Ginsburg on behalf of the appellant, Ho Lee Brice, who's appealing his conviction for robbery and 40-year sentence. We've raised four issues. I'd like to reserve 2 minutes for rebuttal. We've raised four issues in the brief, and I plan to try and address the first two issues, the jury selection and the mistrial issue. We submit that the trial court abused its discretion in conducting an inadequate inquiry into the genuineness of the reasons for exercising a peremptory challenge. The trial judge jumped the gun in making his genuineness finding before asking defense counsel how, given the circumstances, the explanation that the state gave is a pretext for discrimination. As we're relying on the Landis versus State case from the 4th DCA, we feel that's the closest case with the most analysis of an issue, particularly involving the objection that the state gave here, which was based on the juror's employment. The state objected to juror Cynthia Rodriguez, who was a name analyst for Nielsen ratings. The only questions asked about her employment was, who did she work for? What's a name analyst? And she basically replied, I work for the local stations group, making sure that they follow the guidelines that Nielsen has for the stations. And then the state followed up with, so you're making sure they're complying, basically? Yes. And that's the extent of the examination about what she did. Now, the judge analogized her to an engineer. She's clearly not a rocket scientist, an engineer, or another occupation that has been accused of or considered by courts to be a valid reason for overanalyzing evidence.
Well, so the court can consider the juror's occupation, correct?
Yes, Your Honor. But
well, in Landis, you cite Landis. In Landis, neither attorney asked any questions of that particular juror in that case. Does that make a difference here? At least we have a juror answering and giving a job description.
I think what I'm relying on in Landis, if you look at, there's a whole string cite of cases where they talk about this one was an ESE teacher, but there were no questions asked about how that would, you have to tie it together with the reason that you're giving, and they didn't demonstrate on the record how, given her occupation, would that affect her view of DNA evidence? Or I don't think the state had to get that specific, but there just really was no follow-up.
Her explanation of her job was not very enlightening in this case.
No, exactly. It was a vague explanation. We really don't know what she does. We don't know what type of level employee she is. We have no idea what she analyzes. So to justify the reason as she overanalyzes, she might overanalyze the DNA, I don't think is supported by the record. And that's the primary argument.
What about the fact that she's a victim of a crime?
Well, Your Honor, there were at least 15 jurors in the voir dire that were also crime victims. So I don't think that reason...
But isn't that race neutral?
It is a race neutral reason, but you have to look at also whether there were other similarly situated jurors that served on the panel. There were 2 jurors that served on the panel that were also, or at least one that was a crime victim, Stephen Maruzak, the student at University of South Florida studying info technology.
Yeah, but defense counsel point that out below.
In which case, Your Honor?
Well, you're saying, you're giving us a description of the other jurors serving and so whether they're victims of the crime, but did defense counsel notify the court of that below?
No, but the judge did not even address that reason. He based his reason and the genuineness of the objection to the jury on the occupation, making the analysis to the engineer. I would submit that the case law is a little bit confusing about what the appellate court is supposed to do. My position following Landis, which cites Supreme Court precedent, is that if the trial court fails to go back to the counsel that was opposing the objection based on the race or ethnicity and ask him, what do you say, then this court probably can't go back and do the analysis, and maybe my brief may be wrong, that you can't go back and look at these other jurors. I think it's either you just stop and say, he really didn't conduct the genuineness analysis completely, therefore we're bound and have to reverse for a new trial, or some of the older cases that I cited in my supplemental authority from this court, in Daniel and Schuler. In those two cases, there's no discussion about whether or not defense counsel raised this below, but the court does the analysis that they look at other similarly situated jurors and say, well, these people sat and they had the same thing, and therefore it wasn't genuine. So I'm not myself completely clear of the proper analysis. I think I'm going to submit today that if you follow Landis, you don't even need to go and look at, did defense counsel say this? Well, he didn't say it because the judge never asked him, and it was the judge's, well, the defense counsel has to preserve the record. The judge has to follow the inquiry steps, the procedural steps, and procedurally, he never turned to defense counsel and asked him, what do you say to these reasons, counsel?
Well, is the procedure where he's supposed to inquire of defense counsel, or the trial judge is supposed to analyze the neutrality of the reason?
Well, I think they have to do both, but they should analyze the reasons after they've considered what defense counsel says. If he had asked defense counsel and he didn't say anything, then the reason could be upheld.
Well, does the record indicate that the judge cut off counsel and did not permit him or her to respond, or?
I would submit yes. Okay. And that inquiry was on as soon as the state gave their reason about the DNA and that she may be scrutinized, and I don't want her scrutinizing my witnesses, the judge just says, all right, for the reasons articulated, I'll find this to be race neutral, to be more akin to a strike of jury strategy, not wanting an engineer, overthinking a case. I'll find that to be race neutral. I'll find it to be genuine. So that's on page 189 of the record. He did not go back to defense counsel before making his ruling. So we submit that the case should be reversed and remanded for a new trial on that basis. If there's no further questions on that issue, the second issue I'd like to briefly address is the motion for mistrial based on the Detective Minor initially testifying that when they showed him a photograph and asked the officer if this is the way the defendant looked that evening, and he said, I assume so. He's been arrested a few times. There was an immediate objection. There was a sidebar. There was a long discussion about how we're going to undo this, how do you unring this bell, and the judge kind of suggested the only reason is, the only way you could do it is if you said he looked at driver's license photographs. So then after a break, they come back and the state says, oh, the officer did in fact look at driver's license photographs and he was mistaken.
That wasn't the question that was put to him, right? It wasn't, did you look at this photograph and then go look for him? The question is this how he looked that night?
Exactly.
This was, and the trial was 4 years later, correct?
Yes.
Because I'll tell you, I have a little concern that, he testifies 4 years later that the defendant has been arrested a number of times, and then it seemed to me, arguably, that then the discussion and the fix for the jury focused on what picture he had looked at that night or that day, and proceeded as if he had said he had been arrested several times up to that point. Because fixing that didn't really alter the fact that what he said was he has been arrested. 4 years later, he has been arrested several times. and that does concern me, that if the jury picked up on that nuance. it wasn't fixed.
And that's our position, that even though they tried to fix it, give a curative instruction, change his testimony, that the jury heard that he'd been arrested a few times, then he said it wasn't the photo he looked at. It doesn't discredit the fact that he was arrested a few times. And so our position is that the court, the conviction should be reversed on this ground as well. If there are no further questions, I'll use the remainder of my time for rebuttal.
Okay.
Thank you.
Thank you, Ms. Ginsburg.
May it please the court. Good morning. I'm Suzanne Bouchard, representing the state of Florida in this case. I'll address the two issues that Ms. Ginsburg has addressed in the order that she addressed them. Talking first about the voir dire issue. It's the state's position that this issue is not preserved for appellate review. And this is not a situation, when you look at the record of this case, there's really no indication here that the defense attorney was cut off or anything like that. The trial judge did move on. We have a cold record. We don't know the pace or anything of how this went. But what we do have is a situation where we had the trial judge go through the steps. The prosecutor gave a reason for the strike, which was the occupation and the prosecutor's fear that this person who was an analyst and who followed, the protocol of Nielsen Company and follows up with television stations and that sort of thing, would be overly analytical to the evidence, and the prosecutor specifically mentioned, DNA evidence, and there was DNA evidence in this case. The trial court found that that was a genuine, a facially race-neutral reason, and that it was genuine on the part of the prosecutor. Now, the cases from Florida courts do not place upon the trial judge an obligation to ask the defense attorney, hey, is this all right with you? What the cases provide, and if I'm specifically looking at the Hoskins case, if the proponent of the strike proffers a facially race-neutral reason and the party objecting to the strike has to preserve the issue by putting the court on notice that they find that to be pretextual. And the cases talk about, and especially when we look at the cases that have been cited by appellant in this situation, the Daniel case, the defense attorney objected and stated that the prosecutor's reasons were pretextual, and from there, the trial court just summarily ruled that the prosecutor's reasons were race neutral and didn't go forward with a genuineness finding. And in Schuler, that case, it looked like, when you look at what the court has written in that case, it almost looks like the trial court didn't really even know it was supposed to go to a genuineness analysis, because what the trial court said in that case was, I'm not allowed at this stage to consider whether these are good or bad reasons as long as they're race-neutral reasons. So in that case, I would, differentiate that by saying, there the trial court didn't even go to that step of finding that it was genuine. So there has to be the genuineness finding, but in order to preserve it, it's incumbent upon the defense to say, hey, this really isn't genuine based on the facts and circumstances of this case. Defense counsel didn't do that. And Hoskins provides that if the defense counsel fails at trial to question the facts on which the strike was based, that issue is not preserved for appellate review. And it's the state's position here that the issue is not preserved because defense counsel apparently accepted the genuineness finding here.
But when the court stated on the record that I am reserving all of your objections, you don't believe that that was reserving counsel's objections to the race-neutral reason?
That's a different waiver, Your Honor. I think that, we've got, if you look at Melbourne, the Melbourne case talks about how it's incumbent upon defense counsel, if you want to preserve this, to object before the jury is sworn.
Well, that's the objection to the panel.
That's
so
correct.
You're saying in order to preserve this, there needs to be a specific objection to that juror as to the genuineness.
I agree, Your Honor.
Is that what you're saying?
That's exactly what I'm saying.
Okay.
And that's what the cases provide.
And ultimately object to the panel having failed on that. And
Correct. So we've got...
You're saying the judge saying your objections are preserved prevented a waiver from the latter.
That's correct.
The latter waiver.
There are a couple of waivers here.
Right.
The first one is the one I discussed about no objection to the finding of genuineness. The second waiver is we had a kind of a unique situation here. We had a different trial judge doing the voir dire, and then it appeared to be later in the day, or, you know, I don't know how much later, but it was the same day. A different judge comes to the bench. That is the judge who heard the trial, Judge Federico. And there were other matters that were discussed before the jury was sworn, and this was not one of them. And Melbourne says, in order to preserve this, you've got to raise it before the jury is sworn, because matters proceeding after this initial, you know, objection might have cured it in the mind of the defense. Maybe they talked it over and said, hey, we're kind of happy with the people we got. Let's not stir the pot anymore. So it's the state's position that this is waived, not just at the time that the strike was made, but also before the jury was sworn. And I do understand that there was, you know, the first judge said, well, you're not waiving any objections and all that, but I would still assert that based on Melbourne, it was incumbent upon defense counsel to say, you know, we want to object to the panel because of this situation that we had here. I would like to move on to the second issue here, the one about the motion for mistrial. Obviously, you know, what happened here was we had a non-responsive answer to a question the prosecutor asked. The deputy or detective said, I assume so, he's been arrested a few times. Well, the jury was you know, there was a motion for mistrial. Jury's immediately sent out to lunch. And the parties talk it over. The prosecutor looks at the police report that this detective had done, and they're trying to come up with a way to cure this. And according to the prosecutor, and we don't have the police report, but the prosecutor said, you know, before he went out to make the arrest, and he's not the case agent or anything like that, he's just one of the arresting deputies, he looked at photographs, and apparently, according to his police report, he looked at driver's license photos. So what they came up with for a cure, and this was over defense objection, was to have the law enforcement officer say that he had been mistaken when he said that the appellant had been arrested a few times.
Okay, and see, and here's my concern. Those are two different statements, because he testified he has been arrested a few times. And then the cure was, oh, he was mistaken that when by saying that when the day he was going to arrest him, he had been arrested a few times. And there's a 4-year gap between the two. And so on the face of it, the problem wasn't cured. Now, I recognize that's a nuance that in practice the jury might have missed, you know, and I think maybe the judge and at least the prosecutor, and perhaps the defense attorney at the time might have missed that. But can we decide this issue? Because that's a huge problem in the case.
I understand that. I think,
based on our hope that everyone missed the nuance.
Your Honor, I think in this situation, absolutely. I think it was made very clear to the jury that the law enforcement, I mean, nothing was mentioned to the jury the second time around about, well, what happened to his arrest during the ensuing 4 years. I mean, that's clearly the impression. If I'm listening to the testimony and he's sitting on the stand and they said, is that how he looked that night? He says, well, I suppose so. He has been arrested a number of times. And then I'm come back and told, well, at the day of the arrest, he hadn't been arrested many times. Those are two very different things. I think that this was cured because it was made clear that the law enforcement officer was mistaken about saying that he'd been arrested a few times. And I think that, you know, maybe there's a little bit of, if you're looking at it, maybe you're giving the jury a little more credit than they might.
Well, that's the question I have. Okay.
Okay. Well, I think
this kind of error the law pretty much treats it as kind of devastating in a trial, correct? I mean, it's
Well,
a big
I mean,
one.
and
this judge said at the time, I'm not sure we can keep going.
right, and they fashioned.
So it's a major issue that we have to examine very carefully, obviously. So on the face of it, on the black and white type and page, it didn't look to me like it got cured.
Well, I think.
But it's a nuance, and can we
That's
indulge in that?
That's a very
I mean,
high level nuance, I think, and I think
that's how I roll. No,
I understand. I'm not so sure the jury rolls that high level.
All I've got is the cold record, but that's all I ever have. So
understood, but I think I want to, I just want to emphasize here that the jury was told.
He was mistaken when he said that he had been arrested.
Well,
and then they get off on this. Well, he looked at driver's license photos, but that wasn't what the testimony.
Well,
had been
no,
about.
and that wasn't necessarily that was just kind of a let's move it away from this. But I think what we've got the law enforcement officer saying in direct examination, I was wrong, I didn't mean it. In cross-examination, I was wrong, I didn't mean it. We have a curative instruction by the trial court as well saying, don't listen to what he said before, he didn't mean it. Well, and then also even
that instruction said, had been arrested.
Again, it's the state's contention that this did cure this matter. And if you look at it, this was a motion for mistrial. And it has to be bad enough that it vitiates the entire trial. And it's the state's position here that having the law enforcement officer say, I was wrong, I made a mistake. I was wrong, I made a mistake. And then you've even got, when you skip ahead to the motion for new trial, the trial court even pointed out to defense counsel, look, you were even able to use this mistake by the law enforcement officer to argue credibility on the part of all of the state's witnesses and saying, these people don't remember what they're talking about.
Well, under the circumstances, I don't think the defense attorney had a choice.
Well,
because he continued to move for a mistrial, and the judge was intent on curing this, what he had at first thought was devastating.
Well,
my perception is the judge and the prosecutor really wanted to move this trial, cure this as best they could. Hindsight's 20/20. We probably could have said something a little bit more effective with a better nuance. I agree, but it just appears that there was an intent to move this case along. Now we're looking at an abuse of discretion standard. Did this judge abuse his discretion in pursuing this path?
And the level there would be that you would have to find that no reasonable trial judge would have done what he did.
But that analysis doesn't include the fact that the defense attorney used it, because he had no choice.
I understand that. I understand
so he's
that.
got to use whatever he can and try to twist it and shape it and use it to his advantage. So that's not even part of the analysis. So the analysis is, what was the question that was asked? This is a booking photo. Did he look like that night? And I know the state didn't intentionally do that, but the officer said, well, he's been arrested.
And then the officer came back. The next thing the jury heard was, I made a mistake. I was wrong about that. I made a mistake. I was wrong. And he said it. He repeated it several times. And it's the state's position that comment, in light of the cure and the instruction, did not vitiate the entire trial here. So if there are no further questions, the state would ask that this court affirm the rulings below.
Thank you, Ms. Bishop.
Thank you.
I'll start with the mistrial issue first. And I think, both Judge Sleet and Judge Northcutt have cut to the heart of the problem and the analysis. We submit that the trial court did abuse its discretion in pursuing this path. The state sort of referenced a police report that's not part of the record, but I mean, the fact of the matter was the client was previously arrested and convicted. That's why he ended up with a 40-year sentence, because he had a record. So the jury heard it. I don't think that the correction unrung the bell The defense counsel did the best he could with what he had, and really, the client is entitled to a new trial on this basis. And as for the first issue, there were multiple preservation arguments. The no objection to the finding of genuineness, that goes back to, we're citing Landis, which cites other Supreme Court cases, Reynolds and Huskin for the analysis. I said the wrong name, Reynolds and another case, I think it's Dees, that cites the analysis that the court must turn to defense counsel and ask him anything you have to say about these state's reasons. The state's relying on Hoskins, which says, which doesn't really address that, or actually other reasons were given by defense counsel. It's not the same reasons that were raised on appeal. So it's a different preservation argument that was made. He didn't argue the same thing on appeal that he argued in the trial court. Here, we're saying defense counsel never got to make his argument because the judge did effectively cut him off. And right after he made the comment about, okay, I'm finding it's genuine, he moved right to the next juror. There was no break. And then the second preservation issue dealt with renewing the objection at the time the panel was sworn. Our position is it wasn't necessary because the Judge Meyer preserved the issue for defense counsel. So for those reasons, we'd ask that you reverse and remand for a new trial. Thank you, Your Honor.
Thank you, Ms. Ginsburg. Thank you both. Our next case is Long versus Nation Star Mortgage.